Okay, good day, everyone. Thank you for joining us for our webinar, The Supreme Court in 2016, 4 cases that will impact Asian Americans and Pacific Islanders. My name is Anthony Bowman, and I am the Community Partners Network Manager at Advancing Justice AAJC, the DC-based affiliate of Asian Americans Advancing Justice. I am joined today by 4 speakers, each of whom will share the background of one of these 4 cases, including how each got to the Supreme Court, what is at stake, and how the court's decision could affect you and your community. I'm going to let our speakers introduce each case to you. We are going to have a Q&A session at the end after all the speakers have presented, and we'll use the questions feature on your GoToWebinar control panel to receive questions. In the coming days, we will share fact sheets on the cases covered today, which you can also view right now in the handout section of your control panel. We are recording this webinar and we'll post the information online for you afterwards. Before we get started, I've just been told we have some difficulty. People aren't able to access the Fisher handout. We will try to rectify that internally here, but if we aren't able to do so, please know you will receive it in the coming days. So now I'm going to hand it over to our first speaker, Terry Almanis, who will present on Evenwel versus Abbott. Terry is the Director of Census and Voting Programs for Asian Americans Advancing Justice, AAJC. Terry co-chairs the Leadership Conference on Civil and Human Rights Census Task Force and co-counseled the Civil Rights Brief in Evenwel along with 6 other civil rights organizations. She has co-led campaigns on the 2006 Voting Rights Act reauthorization, the 2010 census, and the language assistance election protection efforts.
Thank you, Anthony. Pulling up the slides really quickly. Evenwel v. Abbott was argued recently before the U.S. Supreme Court, December 8th, and should be decided by the court sometime before the end of June 2016. 1 second. Sorry, I'm trying to get the PowerPoint working.
There we go.
This is a case that challenges the longstanding practice in the United States of counting every person when drawing electoral districts. This case comes out of Texas, where registered voters brought a challenge to how the state Senate district lines are drawn. So in 1964, the U.S. Supreme Court ruled in Reynolds v. Sims that the Equal Protection Clause of the 14th Amendment requires the states to draw legislative districts with roughly equal populations. This principle of one person, one vote has largely been the law in redistricting matters ever since. Since Reynolds was decided, almost all states and local jurisdictions draw electoral districts based on total population. That is, the complete count of all persons conducted by the U.S. Census Bureau each decade. This way, elected leaders represent equal numbers of people in each district. In this case, Sue Evenwel and her fellow appellants want to require electoral districts to be drawn counting only voters. They propose that this measure of voters can be calculated in a number of different ways. One way would be to use citizen voting age population, that is, estimates of the number of citizens over 18 years old, based on an annual sample survey by the Census Bureau that is then averaged over a number of years. A second method would be using voter registration, that is, numbers maintained at state and county level that may be influenced by efforts to create barriers to registration, disqualifications of certain citizens over 18, such as ex-offenders in many states, and voter purging practices. And finally, they propose using voter turnout, numbers maintained at state and county levels with high volatility from election to election. Any of these voter methods would result in districts with dramatically different total populations and less representation for communities with fewer voters. So there are 4 main possible outcomes of the forthcoming Supreme Court decision. The court can decide in favor of voter equalization, and that would be deciding in favor of Evenwel, and that would mean that every jurisdiction would have to redraw districts to attempt to equalize voter populations. Depending on the measure of voter population, Redistricting could be required more frequently than once per decade, perpetually in the future. Another outcome could be the total population equalization, where the court decides that districts must be equalized based on total population as determined by the decennial complete count census. This would mean prevailing practice would continue nationwide. A third outcome could be the states' rights decision, where the court decides, as urged by defendant state of Texas and Evenwell, that each state may decide on its own whether to use total population or voter population in equalizing electoral districts. This outcome would undoubtedly trigger an effort in certain states to shift from total population to voter population. And finally, the court could decide that districts must be drawn to equalize both total population and voter population. This outcome would likely require the drawing of bizarrely shaped snake-like districts, a phenomenon long disfavored by the court in many jurisdictions. So why does this case matter? Because the plaintiffs in Evenwell are making their arguments under the U.S. Constitution, a decision in their favor would affect all electoral districts, from the local city council or school board up to state legislature and congressional districts. If the challengers in the radical constitutional theories prevail, it would override the choice of Texas and other states have made and would require chaotic and massively disruptive redistricting across the United States. Evenwell's proposed approach would manipulate the redistricting process and skew legislative seats and representation, injuring voters and non-voters alike who live in areas with more children in areas that are more racially diverse, such as cities. Let's remember, legislative districts determine government representation and resources. Areas with more children and other non-voters deserve full representation and should not be penalized by losing legislators and legislative seats. Children are the largest group of people in the country who are not voters, and they deserve to be represented by our elected officials. If we abandon the use of total population for districting, communities with larger numbers of children would lose much needed representation and resources. And this is true, of course, for all groups of non-voters, such as non-citizens. State legislators make crucial decisions about funding for things like roads and schools that every person in the community depends on and benefits from. So it's important that districts are drawn to represent everyone in the community. Our elected leaders don't just represent the people who vote, they represent everyone in their districts. Finally, how district lines are drawn are based on the U.S. Census, which is already being designed for 2020. Changes at this point would put the accuracy and cost effectiveness of the population count in jeopardy, specifically hitting AA and HPI communities, which are traditionally more difficult to count. A ruling for Evenwell could necessitate changes to the census form depending on how the Supreme Court ruled. For example, it could mean the U.S. Census Bureau would have to begin to field questions around citizenship in order to determine eligibility to vote. Not only does it take years to research, develop, and test new questions, this question could also deter many communities, such as ours, from participating in the U.S. Census and thus from being counted. So some quick data points about how a decision in Evenwell, a problematic decision in Evenwell, would impact our community. So we know that moving away from total population as a standard for redistricting would have a more harmful impact on our communities. If redistricting is done according to number of registered voters, hundreds of thousands of AA and HPIs would be disenfranchised. For example, between 500 to 700,000 of the million Asian Americans, Native Hawaiians, and Pacific Islanders living in Texas are not registered or eligible to vote. We also see that voter registration and turnout levels for AA and HPIs nationally are consistently lower than that of non-Hispanic white citizens. This means nationally, millions of AA and HPIs could be disenfranchised if the long-standing one person, one vote standard is not upheld as the proper way to draw legislative districts. And to flag, we also saw Latinos had similar lower registration and turnout rates, 51% for voter registration and 27% for turnout. And so other communities of color would also see such a similar impact. If the change was to standard of citizen voting age population, this would also be problematic for our communities. As you can see here, 40% of NHPIs and 45% of Asian Americans would be excluded if districts were drawn based on citizen voting age population, as compared to only 21% of non-Hispanic whites. Other communities of color would be likewise harmed, where we see 55% of Latinos being excluded, 30% of African Americans, and 31% of American Indian and Alaskan Natives. So this is a very important case for our communities and for democracy as a whole. We will keep community partners and friends updated when the decision comes down, and will continue to engage in education around this important issue. In the meantime, please feel free to use our resources to help educate others about this case. We have a webpage that has a shareable infographic and a one-pager about the case. We have a blog post laying out why this case is so important for our community. And finally, the Civil Rights Amicus Brief that goes into more details about why total population is the appropriate standard and how all other standards would harm our communities. Back to you, Anthony.
Thank you, Terry. Our next speaker is Nicholas Espiritu, who will present on Texas versus United States. Nicholas is a staff attorney at the National Immigration Law Center. His work centers on protecting the rights of low-income immigrants through litigation and administrative advocacy. Currently, Nicholas litigates cases challenging state anti-immigrant ordinances, discrimination against DACA recipients, and detention issues. Nicholas, can you hear us?
I can hear you guys. Can you hear me?
Yes, absolutely. Wonderful.
You guys hear? Okay, great. Thank you so much. Thank you so much for that introduction. So let me minimize this control panel, and so is my screen showing correctly?
Yes, everything's good.
Great. So we're going to talk a little bit today about the case Texas v. United States, which is a challenge by the state of individuals. This case is currently being asked by the U.S. government for review for the United States Supreme Court. So I'd like to talk a little bit about the DAPA and DACA programs being challenged and what this the main issues in this case. So for those who aren't familiar, in June of 2012, the Department of Homeland Security issued a memo creating the Deferred Action for Childhood Arrivals program, commonly known as DACA. As folks may know, this program allowed certain undocumented youth who came here as children and had completed high school and met other requirements to receive deferred action. That is, a promise not to be deported for 2 years, as well as to receive work authorization, that is, to receive a work permit. As a result of this program, in this announcement, in August 14th of 2012, U.S. Citizenship and Immigration Services, USCIS, released the DACA application. And on November 20th, 2014, DHS announced DAPA and expanded DACA to include more folks. And I want to emphasize that it's really only the latter two programs that are currently enjoined. The DACA program that was announced in June of 2012 still is in effect. So I just want to talk a little bit about the benefits and limitations of deferred action. So as I said, the benefits of deferred action, such as the DACA and DAPA programs, are protection from deportation, receipt of work authorization, the ability to get a social security number, and now in every state with that work authorization, individuals would be able to get a driver's license, and there is the possibility for individuals to request permission to travel abroad. The limitations of these programs are that they don't provide a green card or a visa. None of them are a path to citizenship, and all of them potentially could be eliminated by this president or a future president because they are just discretionary grants of prosecutorial discretion. So what has been I want to talk a little bit about what the impact of DACA has been. So to date, roughly 665,000 people have received DACA. And a recent survey of DACA recipients have found that a full 96% of respondents are currently employed. That is, a full 96% of respondents who have received DACA are currently employed or in school. Of DACA recipients currently in school, 92% are pursuing educational opportunities they previously could not. Many of these individuals are getting better, higher paying jobs than they had before they received DACA, with individuals on average earning 45% more than they did pre-DACA. Many are getting licenses and buying cars. 89% got a driver's license or state ID, and 20% of respondents bought their first car, which results in tax revenues for the state which they purchase it in. So just to go over very quickly what some of the changes that were proposed in November of 2014 were. One of the proposed changes was to expand DACA eligibility, to remove the age cap that had previously existed, to push the eligibility entry date to January 1st, 2010, where it had been previously June 15th, 2007, and to change what had been a 2-year promise of deferred action and an EAD to 3-year deferred action and EAD. In addition to the proposed expansion of the DACA program, the November 2014 announcement also created a new program, which is referred to as Deferred Action for Parents of U.S. Citizens and Permanent Residents, and is commonly referred to as DAPA. Here, the program made parents of a U.S. citizen or green card holder as of November 20th, 2014 also eligible for deferred action and a work permit. The other requirements include that the individual have continuous residence since January 1st, 2010, that they have had physical presence in the United States on November 20th, 2014, and at the time of the request, and that they didn't have lawful status as of November 20th, 2014. So these two programs would have expanded the pool of individuals who would have been eligible for deferred action from about 1 million to about 4 million individuals. And based on the success that the DACA program had in building educational and economic opportunities for individuals, we here at NILC and many other advocates had hoped that the DAPA and expanded DACA programs would have seen very similar gains for immigrant communities and their families. So while these programs were announced in November of 2014, shortly after in 2014, Texas and 25 other states sued the Obama administration seeking to block these programs. They brought a lawsuit in a Texas federal district court, and on February 16, 2015, that federal court temporarily blocked the DAPA and expanded DACA programs. Once again, I'd like to reiterate that the initial DACA program was not enjoined and was not part of the lawsuit. The federal government sought an appeal, and on November 9th, 2015, 2 of the 3 judges on a Fifth Circuit Court of Appeals panel sided with the Texas Federal District Court, saying that the programs should remain blocked temporarily. So I want to talk about what are the main legal issues in the lawsuit. It's actually the second bullet point, but it's one of them. It's the argument that Texas was making regarding why DAPA and expanded DACA should be blocked. The first argument was that the Federal Administrative Procedure Act requires policies like the DAPA program to have been put through formal notice and comment rulemaking. That is, for when the federal government seeks to pass binding rules that implement federal law, they are required to put this through a notice and comment process to allow the public and other interested individuals to comment on the proposed rules to implement those laws. The second major legal issue is whether the DAPA program itself was consistent with federal law. That is, does the INA permit the president to enact prosecutorial discretion programs like DAPA and expanded DACA? And those are the two main arguments that Texas and the other states advanced as to why the DAPA and expanded DACA programs should not be allowed to go into effect. Another main legal issue that came up was whether states like Texas have standing. That is, are they actually injured in by policies like the DAPA and expanded DACA program, and allowed to challenge the executive's immigration policy, in this case based on Texas's argument that if it was forced to provide driver's licenses to DACA, to DAPA and expanded DACA recipients, that it would lose money because it subsidizes those licenses in some way. So those are the main legal issues which are now being put to the United States Supreme Court, which have been at issue at the district court, at the federal appellate court, and now the federal government is asking the United States Supreme Court to review. So what are the real-world consequences of the potential to have DAPA and expanded DACA in effect? As we know, DAPA and also expanded DACA will allow qualifying individuals to have the ability to improve their lives, the lives of their families, and their communities. We also know that family units will be more secure because given DAPA and expanded DACA's promise not to deport individuals for a span of 3 years, that these families will be more secure and will not face the looming threat that their loved ones will be deported. NILC, AAJC, and the Leadership Conference all submitted an amicus brief highlighting these stories in a coalition of over 200 civil rights organizations that put forward the real stories highlighting the effects of the lack of the DAPA program and what would be the benefits of allowing these programs to go into effect. This amicus brief was submitted in support of the federal government's petition for certiorari, that is their appeal to the Supreme Court. Similarly, law enforcement officers, cities, and states submitted amicus briefs in support of the DAPA program and in support of Supreme Court review because of the benefits that they saw to public safety. And similarly, cities and states have also emphasized in an amicus brief to the Supreme Court the economic benefits that would be conveyed through these programs. And in this webinar, there's a link to the full list of amicus briefs that were submitted at the Supreme Court stage. Very quickly, I would like to go through a timeline for Supreme Court review. So on November 20th, 2015, 1 year after the announcement of the DAPA program, the Department of Justice filed their appeal to the Supreme Court, their petition for certiorari, to review the Fifth Circuit's ruling in Texas. And the amicus briefs were filed shortly after, a week later. Texas is required to respond by December 29, 2015 as to why it disagrees with whether the Supreme Court should review this case. And we believe here at NILC that this current schedule allows sufficient time to allow the court to decide the case this term if the court agrees to take the case. So Looking forward, we expect that the paperwork requesting that the Supreme Court take the appeal could be in the justices' hands as early as their January 15th, 2016 conference, where they decide on what cases they'll take. It will take 4 justices that will grant is what the cert petition. We believe that if cert granted by mid-February 2016 or later, the Supreme Court may need to shorten the usual time allowed for briefing on the actual issue in the case. The appeal is granted. The last day the Supreme Court will hold arguments this term is April 27th, 2016. The Justice Department has stated that they will file a request to expedite the case and add a May argument date if necessary. Normally, the late analysis decisions is in late June. We believe that the court, in fact, does have the ability to hear the case this term, and we are encouraging the Supreme Court to take this case, the court to take this case this term, so that hopefully the case will receive a favorable ruling. The DACA program and expanded DACA programs will be allowed to go into effect as soon as possible after that. For more information on the deferred action programs, we have 2 links here on our website. And the second one, also on our website, is an interactive timeline describing what we anticipate the process will be forward. And so with that, I'd like to thank this conference very much. I'd like to thank the attendees.
All right, thank you, Nicholas. Our next speaker is Eugene Che, who will present on Fisher versus University of Texas. Eugene is the Senior Staff Attorney for Litigation at Asian Americans Advancing Justice. Eugene served as co-counsel on Advancing Justice's amicus brief in Fisher versus University of Texas earlier this year. All right, Eugene, it's all you.
Okay, great. Thank you, Anthony. Hi, everyone. Again, my name is Eugene Che. I am an attorney here at Asian Americans Advancing Justice, AAJC. I just wanted to highlight for everyone listening today that I'm going to be talking about Fisher v. University of Texas. The case that was discussed at the very beginning of today's program, discussed by my colleague Terry Au Minnis. She discussed a case called Evanwell. Evanwell and Fisher were argued in the Supreme Court yesterday. Not yesterday, last week. I believe the picture of Abigail Fisher that you have on your screen right now was taken just last week. The case that Nico Espirito just spoke about, Texas v. U.S., has not been scheduled for oral arguments yet, but it is the hope and expectation that the Supreme Court will hear it this term. And the case that Lisa Bornstein will be discussing after me today is called Friedrichs, and that case is scheduled for oral arguments on January 11th. So all of these cases either have been argued or should shortly be argued in the Supreme Court, and we are expecting the court to issue opinions on them all by June. But today I want to talk to you a little bit about Fisher v. University of Texas. And this case, for those of you unfamiliar, is a case involving affirmative action in higher education admissions decisions. To put it in other terms that you may have heard used, the case is about race-conscious, holistic admission processes at the University of Texas. It's a little bit more a mouthful than affirmative action, but affirmative action seems to trigger a knee-jerk response by people, and race-conscious holistic admission is actually probably a bit more descriptive of the process. The short story of this case is that Abigail Fisher, who is white, applied for admission to University of Texas in 2008. She was rejected, and her claim is that the University of Texas violated her equal protection rights, and she essentially was claiming that University of Texas, their race-conscious holistic admission practices discriminated against her by virtue of her race because she was white. So how do we get here? This case is actually the second iteration of this case to come before the Supreme Court. What had happened was the case initially got filed in a federal district court in Texas many years ago. The case was decided upon and got appealed to the Fifth Circuit Court of Appeals, also in Texas. The Fifth Circuit Court of Appeals ruled in favor of the University of Texas, and that decision got appealed up to the U.S. Supreme Court. The U.S. Supreme Court, though, took a look at the Fifth Circuit's decision, decided it didn't like it, and sent the case back down to the Fifth Circuit. The U.S. Supreme Court can do that. And so the case was heard again by the Fifth Circuit, and again they ruled in favor of the University of Texas. And again, Abigail Fisher's attorneys appealed, and again we ended up before the U.S. Supreme Court last week. So the question that a lot of people seem to have is, why did the Supreme Court remand in Fisher 1? Why did they send the case back down to the Fifth Circuit when they had it the first time? And in order to answer that question, I need to explain a little bit of constitutional law to you. And I apologize for doing so, but it might make more sense. When you're, as a plaintiff, when you're challenging a statute or a state action and you're alleging that it's unconstitutional because it violates something like equal protection, a court is going to review that statute or state action on a rational basis or a strict scrutiny basis. Those are the two main levels of review that a court can do. Under a rational basis of review, though, the state only needs to show, the government that is, only needs to show that its actions were rational and that their actions were rationally related to an important government interest. In our case, in the case of Fisher v. University of Texas, the University of Texas is considered to be the government, and so the University of Texas would only have to show under rational basis review that the use of race in its admissions processes was rationally related to an important government interest. Under strict scrutiny review, though, the demands are higher, and actually in our case, race triggers strict scrutiny. So the University of Texas would have to show that its actions were narrowly tailored to serve a compelling government interest. And this is a very strict standard to meet. And actually, a lot of legal scholars who follow this kind of thing have commented that it's a strict in theory, fatal in fact standard of review. And what happened was the Supreme Court in Fisher 1 held that the Fifth Circuit improperly used strict scrutiny and just accepted that the University of Texas used race in its admissions decisions in a manner that's permissible under the Constitution. And the Supreme Court told the Fifth Circuit to try again and to look at the University of Texas's admissions practices a bit more closely. So let's do that, and let's take a look at the University of Texas admissions processes. In order to understand the basic framework that the University of Texas had for admissions, you have to understand that at the time, in 2008, there was a law in effect in Texas called the top 10% rule. And under that law, the top 10% of Texas graduates within their high school class were automatically admitted to the University of Texas without consideration of race. And the number of admittees to UT's freshman class every year under that law, it grew larger and larger over the years, meaning that those students admitted as the top 10% students grew in greater number every year. In 2008, when Fisher applied, 81% of her incoming class was determined by this top 10% rule. This is no longer the case. There's a limit on that number now, but the point is that Abigail Fisher, when she applied, 81% of her class was determined by the top 10%. So we're really talking about the 19% of the 2008 incoming class that was not admitted under the top 10% rule. And in 2008, when considering non-top 10% applicants, the University of Texas employed various measures to evaluate their application. There was something called an academic index. That was the first thing they looked at. And the academic index was they looked at test scores, they looked at GPA, they looked at the classes you took. Then they looked at a personal achievement index. And under a personal achievement index, they would look to an applicant's entire file, and they would look to leadership qualifications, extracurricular activities, the awards that they received, their work experience, and their community service. And then under that, they would also consider special circumstances. And what special circumstances mean is that they can consider socioeconomic condition of the family that the applicant came from. It can consider the family composition, special family responsibilities, and then it could consider race. So really, we're talking about a factor of a factor of a factor that may not come into play for a vast majority of University of Texas applicants, but that's where we are right now. And the Supreme Court has long ago recognized, I should say, that diversity in education is a compelling goal. This case, well, it recognized diversity as a compelling government interest in the 70s. It recognized in oral arguments that last week that it's still a compelling government interest. I'm going to skim right through these slides. You can read them at your leisure later on, but I'm running out of time. But the point is that I'm going to skip over this. The Supreme Court in 2003 was ruling on an affirmative action case, and in the case called Grutter, made the statement, we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. And that was 2003. They approved an affirmative action process by the University of Michigan in that case. That was 2003. It's 2015. At the court last week, the court, a few justices were very pointed in making the comment that it's 12 years later. Where are we? Are we getting any closer to the day that racial preferences will no longer be necessary? Okay, so as far as Asian Pacific Americans are concerned, I remember when I was in college many years ago, someone once told me, before I knew any better, that Asian Americans were not an affirmative action group, and I should not be in favor of affirmative action because of that. And it took me many years to figure out that that guy didn't know what he was talking about. And the fact of the matter is that there is no evidence that Asian Pacific Americans are excluded from race-conscious holistic admissions. There was no drop in Asian American admissions to the University of Texas, even when, sorry, that was my timer. I'm running out of time. But there was no drop in overall admissions to UT. There was no drop, I'm sorry, there was, skipping right to the last bullet point, the inclusion of race when reviewing applicants did not cause a widening of a test score gap between Asian Pacific American applicants and other applicants. There was a test score gap, yes, but that test score gap preceded the use of race by the University of Texas. This last slide here, you may have, I just included for your own entertainment value, you may have heard that Justice Scalia made a pretty insensitive comment during oral arguments last week. It's worth noting because he's going to be one of 8 people to decide the future of affirmative action in higher education admissions. It's 8 people because Justice Elena Kagan has recused herself from this case because she was involved when she was Solicitor General of Texas. So now it's 8 people, and Justice Scalia made this comment that is worth reading if you haven't heard about it already. But that's just for your own entertainment value, and I will turn it back to you, Anthony. Thank you very much.
Thank you, Eugene. Our final speaker is Lisa Bornstein, who will present on Fredericks versus California Teachers Association. Lisa is the legal director and senior legal advisor at the Leadership Conference on Civil and Human Rights. Lisa engages in advocacy in response to Supreme Court cases, voting rights, hate crimes, and employment matters. She coordinates and supervises all aspects of the Leadership Conference's participation in amicus litigation at the Supreme Court and in appellate courts across the country. Lisa, can you hear us?
The third 30-day element, but we
Lisa?
were lucky enough there to talk to an attorney who was like, yeah, yes.
Hi, sorry, Anthony. I think I was muted.
Oh, okay.
Can you hear me now?
Yes, we can hear you.
Great. So thank you all for having me join you. You know, I've worked with each of the folks who spoke ahead of me on different amicus briefs, so it's great to be with you all today. I'm talking about, as Eugene mentioned and Anthony mentioned, Fredericks versus California Teachers Association. The basic background of this case is that Rebecca Fredericks, who's a public school teacher in Orange County, California, brought a case against the California Teachers Association, which is the union, claiming that her First Amendment speech and association freedoms were violated by requiring her to pay fees to support the unions that she was part of. So she wanted to avoid having to pay any costs related to the union membership. So just to give you a little background, over 7 million Americans are members of public sector unions, and nearly 8 million are represented by public sector unions. Over 30% of public sector union membership is made up of racial and ethnic minorities, and 10.4% of the AAPI community is union membership. So when a majority of workers vote to form a union, the union is obligated to represent everyone in the workplace, whether or not they are members. Unions generally have 2 main functions overarching what they do. One is to collectively bargain for wages and benefits for all the employees at the workplace, and then the other is to advocate for political candidates and issues, lobbying on issues that affect the workers. So the legal history here is that in 1977, a case was brought by Mr. Abood against the Detroit Board of Education, claiming that his First Amendment rights were violated by having to pay union dues. In a unanimous decision, the court ruled that so-called fair share fees are constitutional, that unions can collect these fees from all workers in the workplace, whether or not they want to be part of the union. Now, fair share fees are the part of the fee that the union determines goes towards the collective bargaining. So the union determines how much their costs are, takes out the piece that's related to the political activity, and the remaining piece is what is called the the part that's focused on collective bargaining. And for those who don't want to pay for the political activity piece, they pay this fair share fee in order to help counteract the cost that the unions in bargaining in a way that affects the entire workforce. So since 1977, this has been the law of the land. Public sector unions have members, and which includes nurses and firefighters and teachers. And then those who choose not to participate as a union member still get all the benefits of the collective bargaining agreements and pay this fair share fee. In 2013, there was a case brought that the court decided in 2014 called Harris v. Quinn. That was a challenge by home health workers in Illinois to the same concept of the fair share fees. Now, these workers are mostly in-home, either taking care of their children or their elderly parents, maybe having, some kind of a relative or close friend. So they're not generally involved in the other aspects of public employment. The case the decision was written by Samuel Alito, and it was 5-4. Alito was basically on a tear to dismantle Abood, and wrote in the strongest terms that Abood should not stand. However, Justice Kagan, in a forceful dissent, basically argued that Abood is deeply entrenched, that Abood is the beginning and the end of the discussion, and that there should be no question of what the answer is. In the end, they kind of split the baby, and the holding is that so-called quasi-public employees, such as these home health workers, so they kind of carved out these workers as a separate group, don't have to comply with the fair share or agency fee provision. But because Alito wrote such an extensive attack on Abood, he kind of invited an additional challenge by workers who are kind of more squarely positioned in the public sector, which in this case comes in. So Rebecca Friedrich's case in the California District Court, but the argument they made was, look, we know that the Constitution, there is a Supreme Court doctrine and precedent that says that I have to pay these fees. So I'm not asking you to have any kind of a hearing or any motions. All I'm saying is rule against me and let me go to the next court. So the court said, you have to pay these fair share fees, and ruled against her. She took that ruling to the appellate court, the Ninth Circuit, and again said, I know what the law is, just rule against me so I can get up to the Supreme Court. The Ninth Circuit agreed with the lower court and said that the fair share fees are required under Abood, and Ms. Friedrich was able to bring her case, to bring a petition for cert to the Supreme Court, and the court granted that petition, and is set to argue it on January 11th of this year. And as Eugene said, the question really is, should Abood be overruled? Is Abood a violation of the First Amendment? Now, we believe that the 40 years of precedent is what the court should rely on. By overruling Abood, the court would undermine one of the most successful vehicles for economic and professional opportunity for American workers, and particularly for communities of color, for LGBT workers, and for women. Unions have provided a critical path to the middle class for generations of working people, including all the public sector employees that provide services, firefighters, nurses, teachers, etc. Both members and non-members of unions who are covered by these collective bargaining agreements face smaller income gaps, enjoy greater basic benefits, including health insurance, parental leave. They have safer workplaces, better protected against discrimination. All of these protections are in comparison to non-union counterparts. Benefits are basically the product of the union's ability and authority to collectively bargain on behalf of these workers, and the income that the unions are able to collect by these dues are what support the work that they do. The capacity of a union to effectively bargain and represent all workers requires this fair share fee in order to avoid free rider. The free rider problem is really the concern that the court addressed in Abood, and continues to be the concern that unions fear today. Evidence shows that the economic opportunities that unions afford are substantially greater where share rule applies. And finally, the fair share provisions have been incorporated in thousands of collective bargaining agreements, incorporated as an essential element, and have been relied on by workers for decades. So any kind of change to that rule would really undermine the entire public sector labor force in a way that would have very concerning repercussions. Unions, the benefits from union are earnings or improvement in earnings compared to non-union workers. Benefits including health care, retirement plans, family leave, same-sex protections, and protection against discrimination. So in many states, LGBT workers do not have state employment discrimination protections, and there is no federal LGBT protection against employment discrimination. For instance, AFSCME has come up with over 1,000 collective bargaining agreements which protect against discrimination based on sexual orientation, and many also on the basis of gender identity. So the benefits are really quite extensive. And just finally, statistics in terms of union rates. The AAPI community, in terms of women in the AAPI community, had 11.3% of women are part of unions. And from 2013 to 2014, the union membership in the AAPI community increased almost 100,000 employees just in 1 year. African Americans have the highest union participation rate at 13.2. There are also gender and differences in wages based on union membership. So Latinas who are union members or covered by a union contract earn $240 per week more than non-union members. For African Americans, the median difference is $200 per week, and for the Asian Americans, workers earn $30 more per week than non-union workers. Interestingly, pension plan participation also is different based on union membership. African Americans are 27% more likely to participate in pension plans if they're in a union, and the AAPI community has 35% increase in pension plan participation when they are members of communities. So the concern in this case is not only would a decades-old precedent overturned, while it's been relied on and worked very well for decades, but also the economic opportunities that new Americans and also members of ethnic and racial minorities have enjoyed through this union membership has really made a huge difference to the communities and to the families. And so the danger of losing this is quite significant. Thank you.
Thank you, Lisa. So now we're going to take a few minutes for Q&A. We don't have quite as much time as we had hoped. Please use the questions feature on your GoToWebinar control panel to send questions. And when submitting your question, please indicate to which speaker the question is addressed. Okay, well, I guess we don't have any questions at the moment. Should you have questions in the near future that you would like to ask one of our speakers, please don't hesitate to contact them. Their contact information is on your screen. This concludes our webinar on the Supreme Court in 2016. We hope you found the information shared today informative. In the coming days, we will share 4 fact sheets, one on each case, and provide a link to the webinar recording for your reference. We will also be sharing a short follow-up survey with you so you can tell us how we did. Please do share some feedback with us. A final thank you to all of our speakers and to everyone else who joined us today. Goodbye.